Our freedoms rest on another thing as well, and that is the common law tradition. By the way, slavery was abolished in Britain a century before it was abolished in America. The decision of a judge, not invoking a Bill of Rights, but just striking it down. That's the common law tradition. When Dr. Hanif won his rights against the federal police, he did so by going to court and arguing his case, and the judge overruled the federal government. Beautiful act. Confirms our democracy, the common law tradition. Governments can get voted down in the court. In the wharf dispute in 1998, the union won in the court a finding against the federal government and its supporters. That's the common law tradition. It's protecting our freedoms all the time. John McCarthy argued in his submission, can you nominate a right in Australia that's not being protected by the courts or by the parliament? And the third thing on which our rights are supported is the robust freedom of expression you've got in Australia. Governments are traduced in the media every day. I've seen cabinet ministers almost reduced to tears by the injustice they face. Happens on both sides of politics. And I tell them there's no court of appeal on this one. The media is free. And if it wants to defame you, loudly, noisily, within the limits of the libel laws, it can. Now that's what our freedoms rest on. People say we're the only country without a Charter of Rights or a Bill of Rights, the only advanced country without it, but that's a meaningless statement. We're the only country, virtually the only country with compulsory voting, but it works for us. It's our system, it works for us. And New Zealand adopted a Charter of Rights, but New Zealand hasn't got states. It hasn't got the diffusion of power through a federal system that we have. And it hasn't got an upper house. It hasn't got an upper house elected on proportional representation, in which for the most part the government of the day hasn't a majority. We've got that. It hasn't got a written constitution. We've got that. Britain, yes, Charter of Rights, but they haven't got a written constitution. They haven't got a federal system. And by the way, there's very little evidence that the Charter of Rights in the UK has done anything to enhance freedoms. I pointed out in one of the debates I've been in on this subject that under British law, the police have been warning people that to denounce Scientology can now be interpreted under British statutes as stirring up religious hatred. That's in Britain, with its Charter of Rights. And in Britain, there was a demonstration earlier this year where the police used a certain quartering off technique, and a man caught up in the demonstration, a bypasser, died. He had a heart attack while all this was going on. Now, that happened in Britain with the Charter of Rights. If it had happened in Australia, Geoffrey Robertson and Susan Ryan would be waving it around as proof positive that we needed a Charter of Rights. Now, I say again, Australia is one of the freest countries in the world, and while we should never be complacent about it, we have nothing to be ashamed of in comparing our level of freedom with that exists in countries that have got a charter. There's one thing I want to emphasise more than anything else in my short presentation to you tonight. Any charter in any version represents a shift of power to judges. There's no other way of interpreting it. A charter or a Bill of Rights is an eloquent list of things like freedom of expression, freedom of movement, we can all agree with. But what does it mean in practice? Freedom of expression. The tobacco industry argues it should enjoy it. There are 100 other examples where some other right runs up against freedom of expression. At the present time, the politicians, with all their flaws, try to make decisions to iron it out, and judges under the common law tradition try to work it through. Under a charter or a Bill of Rights, decision-making on the necessary balances end up being made by non-elected judges. And that's what's so important in this for you. When I was Premier, I had a delegation in my office. Cardinal George Pell, Archbishop Peter Jensen, they were concerned about a motion of the Green political party in the State Upper House, the Legislative Council, to bring the churches in under the Anti-Discrimination Act. That was a position I had always opposed. If you're setting up a Baptist school at Maroubra you ought to be able to discriminate in favour of a Baptist when you're appointing your principal, or an Islamic school.